Welcome everyone, I'm Russell Alexander. I've been practicing law for over 20 years with the team here at Russell Alexander Collaborative Family Lawyers. You can learn more about how we are approaching COVID-19 and divorce at our Divorce Information Center at our main website. With that, I want to also thank Sarah, my daughter, for doing the filming, and also Daphne for doing the great editing job. Without further ado, let's get into our topic today. Don't have a will? Estate law changes for spouses come into force March 1, 2021. If you have a spouse but don't have a will, take note. These changes are coming, they're already in place, and they could affect you. If you are married but separated with a divorce still on the horizon, then you should pay extra attention because your spouse may end up with more of your post-death assets than you realize. In Ontario, the Succession Law Reform Act is the legislation setting out the regime for what happens to your estate if you die intestate or without a will. If at the time of your death you are married, which includes same-sex marriages as well as married but separated status, then in view of your intestacy, your surviving spouse is entitled to receive a preferential share of your estate. It goes like this. If you had no children together, then upon your death, your spouse simply gets the preferential share off the top of your estate. If you and your spouse had one child together, then your spouse gets the preferential share plus 1/2 of the balance of your estate. If you had more than one child, it's the preferential share plus 1/3 of the balance. Up until March 1, 2021, the amount of preferential share was set at $200,000. If you're enjoying this video and find it helpful, give us a thumbs up or leave a comment in the comment box below. But under recent changes to the Act's regulation, that $200,000 has been raised to $350,000. This increase applies to estates of those who die intestate or after March 1, 2021. For those who died without a will prior to that date, the preferential share remains at $200,000. It's a hefty jump and one that has been a long time in coming. The last time there was a preferential share increase was back in 1995 when it was raised from $75,000 to $200,000. No matter what your marital status is, having a will is a good idea. But if you're married and separated from your spouse, it's a particularly risky time to ignore the need for a comprehensive will to deal with your assets. If you die before divorcing, your spouse could walk away with a hefty part of unintended parting gift from the failed marriage. To learn more about these changes, you can read our full description in our upcoming blog. Please leave your thoughts and comments in the comment box below. If you liked this video and found it helpful, please give it a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.